All right, the first matter to come before the court this morning,
You want this? I have to recheck one.
no, I'm good, is State of Ohio versus Jeffrey Newcomb. Each side will have 15 minutes to present its arguments. The appellant may reserve up to 5 minutes for rebuttal. When you take the podium, if you wish to reserve rebuttal time, hang on for a second.
Sorry.
That's okay. We're going to have a little bit of housekeeping matters
Okay.
to take care of. Just let me know how much time, and I'll do my best to watch the clock for you. I would say, and I will say, we've read your briefs. We're ready to begin. Please don't use the names of any victims or children if that's applicable to your briefs. Couple of matters first. Mr. Gronsky, you requested to our bailiff if you could remain seated for your argument, and you certainly may. She's adjusted what needs to be adjusted.
Appreciate it, Your Honor. I want to point out that I am also hearing impaired along with, I believe, Mr. Newcomb.
And you're also a mind reader, because that's what I was going to next.
Okay.
All right. I'll start with you though. First, Mr. Gronsky, have you been able to hear what I've said so far?
Yes. Yes.
All right. All right. Ms. Bremke, I know you've also spoken to our bailiff. Your client has hearing difficulties. What can we do to accommodate? What requests do you have?
So I originally thought maybe he would want to sit over there because he does read lips, but he indicated to me this morning if it would be okay if he could have his cell phone out because he has an app on there that would help him, assist him. So.
All right. And certainly that's fine. Is it better?
She said it's fine if you have your cell phone.
Yeah, okay. I'm having a hard time picking up voice, it's not loud enough.
Not loud
Okay.
enough.
Couple of things, because I'm not going to be able to get any louder, so I have two options. First, if moving up will help, I don't know if it will or won't, either by you or in the jury box. The other option, and it would depend upon your client's hearing abilities, but I believe this court has the hearing assistant headphones that we could try out to see if that would assist.
That would help really, Your Honor.
All right, let's break for just a minute or two here, and Kid, I'll ask you to see what you can do. But Mr. Gronsky, so far you've been okay?
Yes.
Okay.
Thank you.
Oh, okay.
But we'll see. It might be the better thing, but. Watch, they don't have batteries. That's what we always find out.
I know we don't like it. It's not-
They're gonna try to get headphones.
But it's not
Yeah.
like, yeah.
Those don't work. You could maybe move up here to see what's going on. I'm loud, but maybe not everyone else is.
I know.
The correct way to
Should be
do
able to
it.
pick it up maybe a little bit better.
Kid's here, so let's see.
I'm sorry, I know we've had them before. Jessica isn't here and Darlene doesn't know anything about them.
Do you see anything under the bench here, Judge T, on that side? And do you see anything?
Yeah.
Closer to, to the side of it.
No.
Yeah, I think he would pick up me because I'm loud, but.
Yeah.
Cover it.
I'm gonna let Kid fit real quick, right?
Oh. You found them.
Got power. Yeah, that's what I'm afraid of.
I believe, Your Honors, that might be dependent upon using
Yeah,
the
the
microphones. I just think.
Kit, does it sell?
No.
Oh, is this on?
Here, here's a look. And that's right.
Not getting anything. Well, now that you found those, is there somebody in the back that could help you with those? There's a lot of remotes over there, but you wanna start pressing buttons.
Yeah, I know. I don't see. This is like what we had. This is what we had, and so.
This is small.
This is
There you go. Audio.
I just did something, did you,
What's that?
something turned on down here?
Uh-huh, we just turned it on. We don't want to record.
No. Oh, how about,
It's on.
this would help.
This one's on.
We might have to share. This doesn't come off, does it?
Okay, well, it's in the middle.
I don't see it. My concern is you.
This one's on.
Yeah, this one's on,
Reach.
up here.
Okay, then we just need Kit to see now if we got it synced now that the mic is on.
Well, that's gotta help too.
I think I want that one.
That one's on? You don't.
Attorney Brusky, you have this.
You,
down.
I'll tell you.
I don't know. I've been in this room a million times and oh, there we go. And I didn't even know we had those headphones.
Now what we need to do is make sure the headphones.
There's not one over here, is there?
I think there might be testing.
Is that?
Okay.
Yeah, that's on, I think. Test, maybe not.
No.
Testing?
Now, does it work?
They don't know.
We turned on the thing.
Try it now.
How
Can
about
you hear
now?
me now? Is it making any difference now, Kit?
I don't think so.
Well, test. I hear
It
it, but I
sounds,
look at my
it
voice.
sounds louder though with the,
See, that's
We turned the mic
testing
on.
one.
yeah.
You know what, I wonder
Mr.
if S is
Newcomb,
being on the record or on this recording.
am I any louder now?
You're not gonna hear me.
No, Your Honor.
Any louder now?
Can we pull a chair here?
Does it work with this?
Okay, yes, Your Honor.
So this mic works?
Good.
So it's picking up what I say?
Little bit.
A little bit.
Okay, you're shaking your hand, so. Here are the options that I have
This
for
chair
you.
over here.
We can move you up to a different position and to see if that works. Or we can, well, first of all, we can do that. If that works, fine. If that doesn't work, we can offer you a continuance. So, Ms. Brumke, you talk to your client, see if there's somewhere you'd like to move them, be it at your table or somewhere where it works.
Are you able to turn on the speaker?
She knows.
Is that 100%?
It looks like it's at 100%.
Okay. That's fine. That's fine, Your Honor.
They also said we can continue.
Yeah, I got that. We go like to continue. No.
Go forward.
Proceed. Keep on going.
Make sure we have that.
All right, Ms. Brumke, I heard that you, I'm trying to keep a record here, old trial court.
Sure.
So, but, you offered your client a continuance, and what is his preference?
He wishes to proceed today.
All right, and should we adjust seating in any way before we begin?
Do you wanna move up? Okay.
All right?
You can hear me?
Say it again.
You can hear me?
Not really, but it's pretty good.
Okay, that's not gonna help.
He's gonna have to move forward if he can keep your lip.
Yeah, why don't you come up here?
Or we can even put a chair so we can, like up really
Move it.
close.
Take those chairs are all mobile, we can move one and he can face whichever direction he'd like.
And then you'll have to see me also because my mic,
You can sit here and then you can see me
Oh.
if you wanna read my lips. You know I'm loud though. Is that good?
Thank you.
Can you make sure you can see the other
yeah,
council?
you have to see me also.
He's
I'm
gonna
gonna
sit
be here.
there.
Okay.
You can see him a little bit?
Can you see me?
All right, I think we are now ready to proceed and just let you know about rebuttal time before we begin.
Yes, I would reserve the full amount of my rebuttal time. Giovanna Bremke, on behalf of Mr. Jeffrey Newcomb this morning. We are here today based on charges that led to a plea agreement in the trial court. Mr. Newcomb filed a delayed appeal, which was granted, and we're here today. The trial court, before accepting Mr. Newcomb's plea, made 3 statements, 3 tasks for Mr. Newcomb to complete. One was to voluntarily show to a sentencing hearing. The second was to go for his pre-sentence investigation report at the probation department. And the third was to not pick up any new offenses, commit new crimes, anything of that nature. And Mr. Newcomb was able to accomplish all 3 of those. As a result, or I should back up a little bit, at that plea discussion, when there was the 3 items offered, it was conveyed to Mr. Newcomb that it would be a 1-year community control sentence if all 3 items were completed. There's case law cited in my brief which stand for the premise that if a trial court imposes itself into the plea discussions, then that's an inducement of the plea and an agreement that should be followed. That 1-year community control at the time of sentencing turned into a 5 years of community control. So the agreement was not followed. As further evidence of that agreement, at one point in its transcript, page 12 of the transcript, at one point my client had stopped the proceedings during the middle of the questioning and asked if, he said, and I have a quote, "I thought we had a deal," to which the prosecutor clarified that the deal was not between my client and the state, it was between my client and the court. And that's at that point, I believe, is when the judge had said, I will impose 1 year of community control, and as long as you are able to accomplish these 3 items, which were accomplished. There was some testimony at the sentencing hearing about no new crimes, no new charges, but there was some allegations made by the APA officer and the state, none of which, again, resulted in new charges, but that was essentially the court's justification for the additional 4 years of community control. So it did escalate from, again, 1 year to 5 years, 5 times the amount of community control period. Secondly, the plea was not made in conformance with Criminal Rule 11 in that, well, we even experienced this morning, my client is deaf, he's hearing loss, and that further plays into the fact that before he was advised of his rights, he was asked to plead guilty. He did plead guilty, and then his rights were explained. where in criminal rule 11, in order for someone to plead guilty, they have to be advised of those rights prior to entering that guilty plea, which essentially waives those rights.
Did the court accept the guilty plea prior to reading the rights, or
No, I believe the court accepted the guilty plea after the reading of.
doesn't that comply with the rule?
Again, I think that in order to understand your plea, it needs to be made at the end of the plea.
Is there an indication from the record, or would you suggest, direct us any part of the record that would indicate that your client did not understand his plea?
I think it's pretty clear throughout the record. If you look at the plea hearing, there's many times in which there was a break in the discussions held off or questions asked. Many times, almost every single question. There was a time where there was a question or clarification throughout that plea colloquy.
Did the court ever state that it could sentence him up to 5 years of community control in this case?
I don't know that I don't know that the court specifically said 5 years. I know he did indicate that it was his intention to do 1 year. I don't know that he specifically mentioned the 5 years.
Back to his understanding of the rights he was giving up, did the court provide any assistance to Mr. Newcomb as far as an interpreter or
There was an
any aides?
interpreter.
There was an interpreter. Okay.
You'll see in the record the interpreter was sworn in.
So that was compliant. At any point in time, did the interpreter indicate to the court that your client was having a difficult time understanding what was being said?
No, so the way the interpreter interpreted to my client, but my client verbally responded on the
Okay.
record.
Isn't it common practice in Lorain County Common Police Court for this type of a practice? Asks the defendant how he pleads, reads the rights, and then either accepts or rejects the plea? Seems pretty standard up here.
It's, I would say fairly, it depends on the judge, obviously, of 106, but many of them do it this way, some do not.
So is there any case law out of the 9th District where that has been successfully challenged? You know, your argument that the right should be read before court asks the defendant how to plead?
I'm not aware out of the 9th District that there's any case law.
Okay, thank you.
I reserve the rest of my time.
All right. Mr. Gonski, whenever you're ready.
Thank you. May it please the court, your honors, counsel. I am Richard Gronsky, representing the state of Ohio through the Lorain County Prosecutor's Office. I thank the court for their indulgence to allow me to remain seated based upon my present authorities. While the appellant only raises one assignment of error, she raises 3 issues with that assignment of error. The state believes that they fail at all of the issues, such as did the appellant properly preserve their appeal for the trial court? The answer is no. At sentencing, and I will bring to the court's attention, Mr. Newcomb, the appellant in this matter, did have, I believe it was court-appointed counsel who took the plea with the interpreter present. I believe he hired counsel for the sentencing, and the interpreter was present with the prosecutor and the court. And then the third thing, there was nothing stated at the sentencing that the defendant appellant objected to, stopped the court and said, wait a minute, Judge, 5 years? You promised me 1 year or something like that. Nothing was ever brought to the trial court's attention of a problem with either the plea or a quote, agreed sentence, which there was none. So did the appellant properly preserve this for appeal? The state's answer would be no, and I'll get into that a little bit in just a little bit later. Number two, was there any plea or sentencing agreement represented by the state or the court in open court? The answer is no, except, and I will go into detail just a little bit later, the charge was reduced by the state and accepted by the court and accepted, of course, by appellant, reduced from a felony 2 to a felony 3, which would take it out of the presumed mandatory prison and allow it at the full discretion of the court. So that was a benefit to the appellant here. And then in open court, sentencing, the state of Ohio, through the prosecutor, said that they had no objection to the community control, but would fully defer to the court. No promise, just that they would defer to the court and have no standing objection should the court give community control. That was the only thing that was put on the record. So the answer was there any plea or sentence other than that, which was put on the record, by the court or anyone else? The answer is no. And the last thing is, did the trial court comply with Criminal Rule 11 when accepting the plea? The answer is yes, and I'll get into just a little bit more detail as I, well, bifurcate is 2, trifurcate, I'm not sure. Break it down in 3 different areas here. First of all, the appellant's issue is not properly before the court. When a defendant does not bring that to the attention, an alleged error for the trial court, they waive that error. So to overcome the waiver, the appellant has to show plain error and the violation of substantial and or constitutional rights. That was not done nor argued in this particular manner in their one assignment of error. The sentencing transcript does not show any objection to the sentencing trial court, and appellant doesn't even raise that issue of any alleged plain error that was committed by the trial court. The state believes there was no plain error, and as such, since the appellant has not brought that to the trial court's attention, they waive that right, and this should not be addressed by this court. We would ask, based upon that issue alone, that his assignment of error should be overruled. They have not shown plain error, and it was not properly before the appellate court because it was not brought to the attention of the trial court at the time of sentencing. There was no objection made or any argument made that something was wrong. Second, the state is not unsure, or before I get to second, the state is not sure what the appellant's, I will call it, end game is here, because if there is nothing put on the record as far as a guaranteed or a promised sentence, then the only thing, if this appellate court finds that there was some confusion, is to allow the appellant to withdraw his plea, which puts him back up in an F2 range, starting over. Surely that's not, and I don't know what the appellant is thinking. Maybe that is his end game, but that certainly wouldn't give the benefit as what he was given by the state and accepted by the court at the time of the plea, reduced from an F2 to an F3.
And
Yes.
if I remember correctly, that F2 is a presumption of prison. I was
That's
gonna say
correct.
mandatory, that's not correct.
It's
but
not mandatory,
presumption.
I'm sorry, presumption if I misstated that.
No, you
Yes.
didn't, it was me.
Okay, yes, and I did cite in the state's brief the actual code section where it is the presumption of prison time. There's nothing on the record, there is nothing in agreement to any sentence, there's nothing on the record that said that there would be 1-year community control. So a court can't enforce something that's not on the record. The one thing that they did place on the record, as I mentioned earlier, is the reduction from an F2 to an F3, and that the state had no objection to community control. I want to bring to the court's attention, it is certainly in the record, but in the appellee's State of Ohio's brief, it is on page 9 and 10. and I put the quote down there, and this is the key to pretty much all the factual issues. And I do want to make that as part of my argument. The court stated, do you understand that the agreement reached between you and your you, the prosecutor, and your attorney regarding a sentence, and in this case, there is no sentencing recommendation or agreement. The state of Ohio is deferring to me to make the sentence, which means that I will make the sentence, or I will decide the final sentence for you. Do you understand that? Then there was some discussion. I thought we had a deal, and that's when the state says we have no objection to community control. That was on page 9 and 10, it was on the state's brief. Did the court state at one point that did they say that usually, or what I normally do is give these cases 1 year? Yes, trial court did that. However, he wanted to know through the PSI a background on the defendant, appellant, and some stuff came out at the sentencing hearing that neither the prosecutor nor the trial judge was aware of, and that was even brought to their attention by the defendant's attorney prior to sentencing, that there was a parole violation that he was actually serving time for at that time. I believe it was 120 days. He was about halfway through it. And that was on his cell phone. There was an allegation, but they actually found the parole violation since he was serving time was he had some marijuana in his system. He had contact with other inmates, which was against his parole violations. And the most disturbing, at least in the trial court, was he had either photos or GIF type photos, make-believe photos depicting minor girls' partial breast and genitalia. That was of great concern to the court. So, our argument there was, did the judge say, well, in these cases I normally do that, that takes this particular case of acts that the appellant was being punished for at the time out of the realm of normal, which is why a court could reasonably, based upon facts, say, I'm not going to normally give you 1 year, I'm going to put you on 5 years. And then the court later sometimes said, I'll reconsider maybe giving you just 3 years of community control. He wants to see how the appellant is doing. That is all reasonable. It was articulated by the court. It was put on the record, and the defendant appellant said that he understood everything. I believe he even thanked the court after sentencing. That was, I think, on page 10, where it says, my intention in these cases is normally to put it, so that was on there. The defendant said, you said community control for up to 5 years. Is there any mandatory time? So he's asking the judge questions during his sentencing, or prior to sentencing. No, my intention in this case is normally to put you on community control for 1 year. Was that a promise? Obviously not, given what the judge had just told him. It was all within his prerogative, whether even to sentence him to jail or prison. That key was normally on there. Appellant has shown no sentencing agreement on the record, so his assignment of error, and under that point, should be overruled. Lastly, the state would bring to this court's attention that appellant alleges that the trial court did not follow criminal rule 11 in that they didn't advise him of his rights before accepting the plea. This is just not true. I believe Judge Theodosio brought up the 9th District case. This very fact was covered by 9th District, the 2019 case, State versus Conley, which is cited in page 13 of the state appellee's brief. The trial court does not have to go into a specific order. It would be nice if all of them did, it really would, but they don't have to go in a specific order. So when they ask appellant, do you wish to change your plea? Yes, I plead guilty. He might have gone over some of the facts prior to that, and then went over the other ones before, with the interpreter present, with his sentencing defense counsel present, before he accepted the plea, before Judge Cook accepted the plea in this case. So everything was done pursuant to Criminal Rule 11. Both the constitutional rights, which of course is really like a strict scrutiny on there, you must strictly comply with that, which the trial court did. And then the non-constitutional rights, such as the potential penalty, what the charge was with failure to register, the appellant said he knew what that was about, etc. All of that has been complied with by the record, Your Honors. There's nothing to show that the court, even pursuant to Conley, did not do its part in allowing the appellant to understand all the charges, what his rights were, that he's waiving the rights by pleading guilty, changing the plea guilty, and then accepting that. Yes.
Excuse me, but prior to accepting the defendant's plea of guilty, did the court, thank you, Judge Callahan, prior to accepting the plea of guilty, did the court ask the defendant if he wanted to change the plea that he had previously entered, or does he want to maintain his plea of guilty? What's the record say on that? Or did he just say, I'm going to...
I don't recall. At the very beginning, I believe he said, do you wish to change your plea? And he said guilty before the judge had gone over all of his rights. Yes, I think...
I guess my concern is, once he's heard all of his rights, did he have an opportunity to say, now that I understand these rights, I either still want to plead guilty or I'd like to change my plea? Did he have that opportunity?
I believe he did, Judge. On there, when the judge finally, before he accepted the plea, asked, knowing everything, having talked to your counsel, do you have any other questions of me? Yes, he allowed, there was I believe, a fine discourse between the counsel, appellant, and the trial judge in this case to make sure that he understood.
And I'm not questioning that. You know, there could be a perfect explanation of somebody's constitutional rights, but after having been advised of all those rights and having understood those rights, shouldn't a defendant be given the opportunity to say, well, you know, that plea I previously entered, now that I understand all these constitutional rights, I want to change my plea to not guilty. So, in other words, wouldn't it be a better procedure to say, these are your constitutional rights, before accepting the plea, say, do you still want to enter your plea of guilty? Or would you like to change your previously entered plea, having been informed of all of these constitutional rights? I'm not sure what the record shows on this. That's my question to you.
I know that it was going to be a plea change, and I know that the court did address, he gave over some of the facts on the case, and then asked him, you know, do you wish to change your plea? Yes, to guilty. And then the court went over the other facts with counsel present, with the interpreter present, with everything. I really don't think that the court, could there be a better way? In a perfect world, I'm sure there could, Your Honor. But the thing is, did the court strictly comply with Criminal Rule 11? The state believes he did. Did he substantially comply with all the other rights and explain it to the defendant, allow questions, allow counsel to talk with the client off the record during the middle of the plea change? And he had privately retained legal counsel at the sentencing, and of course appointed counsel during the time. I believe that the defendant knew, as he states he did, knew, understood, and certainly got the benefit of the bargain, even with 5 years. There was a presumption before the plea with the state of an F2, there was an F2 charge. With an F3, there was no more presumption, so he did get the benefit. Yes.
Okay, and with that, your past time, I wanted to give you a little more because of the question. And Attorney Brenke, you had your full 5 minutes for rebuttal.
Thank you. I wanted to address the issue of preserving the record at the trial court. So the issue of whether a plea is knowingly, intelligently, and voluntarily made is not something that needs to be preserved in the trial court record. Through an objection. I cite two different cases that I'm going to bring to your attention. One is the triplet case, which essentially says where there's a promise by the trial court judge, and that promise becomes essentially an inducement to the plea, then the plea is not voluntarily made. So again, we're saying this plea was not voluntarily made because there was an inducement of a 1-year community control sanction, which I should add, when that promise is not followed, it's not voluntarily made. So again, in this case, that promise was not followed, therefore the plea was not voluntarily made.
The promise in this case was my intention, not in this case, he said in these cases, is normally to put you on community control for 1 year. It's not, he didn't say my promise to you, or in this case, I will be imposing.
So there's, I believe it's the Bird case that I cite that says that the judge's actions need to be looked at as a whole. And if you look at right before that sentence that you had mentioned, the question, and to go back to Judge Schaefer's original question about the 5 years, and we're looking at the page 16 of the transcript. The judge actually does say in the plea colloquy, I can give you 5 years. And that's when my client had stopped and said, whoa, 5 years, and that's what was the response. Well, it's my intention to give 1 year. So when you look at the record as a whole and what the discussion was before that, it was in response.
I gotta stop you though. There's a big difference between it's my intention to give 1 year, and in these cases, I would normally give 1 year. Would you agree with me?
Well, again,
or not? You don't have to.
I think that it needs to be looked at as a whole. So was this interference, or intervention is I think what the case law describes it, intervention by the trial court, and in inducing the plea, did that cause the plea to not be voluntary? And that is the argument. There was some discussion about the state didn't agree. There's no dispute. We don't dispute that the state didn't agree. That's clear. The state said they are going to defer to the trial court judge, but it's the trial courts, and that's what the case law that I cite points to. It's the trial court's intervention that deems this non-voluntary plea.
My question is, after this discussion was had, did Mr. Newcomb have an opportunity to, I guess what I want to say is after the discussion was had, and the court said, do you still intend to enter a guilty plea?
I don't think it was phrased that way. I don't have the transcript in front of me, but I believe it was, do you have any questions? Do you understand anything like that? But it wasn't, knowing this, do you want to withdraw your plea?
But he did ask him, do you still want to plead guilty?
I don't believe that was, again, I don't have the transcript in front of me. My recollection is that question was not posed. It was something along the lines of, do you understand, was the final question. Usually there is a final question, like Judge Theodosi had said, do you still want to plead? And my recollection is that it was, do you understand?
All right, I think I found it, and let me know if this changes your answer. In the briefs, it quotes as follows. The court asked Mr. Newcomb one final time, quote, having considered all of your rights, the information on the plea sheets, the information you discussed with your attorney, and the information I went over with you, is it still your desire to plead guilty today to this charge? And Mr. Newsom answered yes. Then the court found the defendant's plea to be knowingly, intelligently, and voluntarily made.
So again, that wasn't my recollection, but I didn't have it in front of me. So that could be that he again asked him what his intention was to plea at that point.
But your argument then, to pick up then, would be, but he said yes because he was under the impression that he was getting 1 year community control.
That's right. And again, if you look at that as a whole, and that question before that was, I can sentence you to 5 years, yes, but I'm gonna give you 1 year. And so that again was an inducement to the plea.
Well,
Okay,
he has an obligation to tell him that the maximum community control period would be 5 years, doesn't he?
Right, but he doesn't have an obligation to tell him, I intend to give you 1 year. And that's the intervention that caused the plea to not be voluntary is, again, I don't disagree that he has, he should tell him 5 years, but the fact that he said, I will give you 1 year is what would render it non-voluntary.
all right, and with that, your time is also up.
Thank
I
you.
Thank both of you for your arguments. We will take the matter under advisement, issue a written decision in due course. It will be mailed to both sides as well as posted on our website and that of the Supreme Court of Ohio. That's everything for this case. Thank you.